do the introductions tonight, but she was ill today. So I get to do the introductions for our talk tonight on how school districts can effectively implement Section 504. And we have the presenter tonight is Jim Rich, and he's the Director of Special Services from the Puget Sound Educational Service District. And he will tell you more. And there were handouts of the PowerPoint, so if you didn't get one, you could raise your hand, and Lisa, and then we'll have a question and answer time towards the end also.
Well, good evening. My name is Jim, and I do work out of the Puget Sound ESD, Educational Service District. And the Educational Service District is a resource that works with the school districts in the Puget Sound region and King and Pierce County, basically. So I work in the special ed area. One of my areas of expertise is the topic that I'm here to talk to you about, and that's Section 504. I kind of like to start with this slide because this issue is what actually made me a sort of a recognized expert on Section 504. I was a director of special ed in a large district like Seattle in Anchorage, Alaska, and we had children who were not making it into special education, but they still had problems. And we were not really doing what we should have been doing with those kiddos. And we got a bunch of complaints from the Office for Civil Rights here in Seattle, and they came up and investigated the complaints and determined that I didn't have 504 procedures in place. Well, this was before the internet, so you couldn't just Google 504 and, get a procedure. So I had to develop my own in collaboration with the Office for Civil Rights, and that became a partnership that I've had for 25 some years. And I've been working since I came to the state of Washington in about 1992 at various agencies in the state, at OSPI, the Superintendent of Public Instruction's office, and now Puget Sound ESD. In all of those times, I've worked collaboratively with a lady named Carolyn Matson, who was one of the attorneys for the Office for Civil Rights. And so the materials that I'm presenting from and the documents that, I don't know if we've got a copy of the FAQ, the frequently asked questions. I think that's going to be made available too. Those documents were all developed in collaboration with Carolyn and OCR. So what I'm going to do today is to try to answer some questions about Section 504 for you. I train a lot of districts. I do this probably 2 or 3 times a month somewhere in the state, and do it in front of parents frequently also. So I'm going to take my standard presentation and kind of walk you through it with an emphasis on deaf and hearing impaired kids, and kind of share with you as families what these two laws, special education and 504, are all about, how they kind of interface, and how your children from birth through high school may go in and out potentially of the need for special education. But 504 is going to probably always be a backup for you, and I want to share with you how that works. And I don't mind being interrupted, so if I start down something, or if I certainly say something that you don't understand, raise your hand. I will get us through the material. I will give you plenty of time to ask other questions also. So that's kind of where I'm going today. To start with, as I sort of said in my introductory comments just now, there's a couple of laws that are really important to you, and the third one actually for adults and families with hearing impairments. The Americans with Disability Act is the third law that I'll talk a little bit about today. But the middle law up here on this slide is Section 504. It's the oldest law we have on the books that deals with disabilities. And it's part of the federal civil rights statute of the Rehabilitation Act of 1973. Section 504 is just one part of that Rehabilitation Act. And it's a civil rights statute, and it's designed to stop discrimination based on disabilities. And that's what Section 504 is all about. Within Section 504, there was a concept called free appropriate public education. And that's the concept that special education came from. And so in 1975, 2 years after we passed this original civil rights law, we passed a funding bill for it. And the point of the funding bill was to fund FAPE, the special ed portion of the law, not Section 504. So one of the things you're going to find when you're talking to school districts is if your child's in special education, they can get federal and state special ed money for the kid. If they're in Section 504 only, they get no money. And so it's not to a district's advantage, obviously, and it's really not to your advantage to be in Section 504 if, in fact, you can be in special ed. And I'm going to talk to you why, as a family, you don't want to be a Section 504 parent if you have the ability to be a special ed parent, because your rights are diminished significantly as a 504 parent as opposed to a special ed parent. And I'll walk you through some of those comparisons so you understand what I'm talking about. The third law up there is the ADA. That's the Americans with Disabilities Act. And what that did is it took the anti-discrimination rights of people with disabilities and put it in the private sector also. Because 504 and IDEA, the Individuals with Disability Education Act, Special Ed, those laws only apply to people who take federal money. But there was still the community as a whole who was serving the public and were still discriminating. And so we passed the ADA in 1990, and that says that for almost any business of any serious size, they can't discriminate based on disabilities. And what that did for your clients and yourselves is that it said that if you go to the play or you go to the football game or you want to access the dentist, then if sign language interpreters, for example, needed to be there, then they had to be provided to you. And that's why on phones and communication we have systems now, and on television why they're closed captioning. All that was caused and was reinforced by the ADA. It basically says if I'm going to serve the public, you have to have equal access. So that ADA was done, and normally I didn't used to talk about the ADA when I do school stuff, which is what I'm an expert on, not the adult world, because the ADA mostly had its impact on employment. You as deaf employees had certain rights for accommodations in the workplace, and that's where interpreter services came in and all those kinds of things that we might need in a workplace. But the ADA, because in the workplace it got so messed up in the courts and so conservative in its interpretation, the Congress went back and amended the ADA to expand the definition of disability. Now, the deaf community really wasn't discriminated in employment in the ADA because you had Voc Rehab and a bunch of people advocating for you, and so it was really designed for some other disabilities, but nevertheless, it did do some changes to Section 504, and so we'll be talking a little bit about that. So those are the three laws, and I wanted to kind of put them in perspective. And for you as families, or if you're a hearing impaired yourself, you need to know that basically, as an adult, Section 504 and ADA are there for you. As a parent with a kid with a hearing impairment, all three laws potentially apply, but really Section 504 or special ed are the main game in town, as long as the kid's in school. If your kid or your student moves on to college or to training schools, then Section 504 and the ADA are the game, because IDEA special ed stops at high school graduation or age 21 if the kid stays in school later. So Section 504 for the adult world, really, IDEA, and Section 504 for the student world. And as a disabled person with a hearing impairment, all three might apply depending on your age and what you're doing. So what is Section 504 about? This paragraph basically is a legal definition of we can't discriminate based on your disability. So your child with a hearing impairment basically cannot be discriminated against because of their hearing impairment. And it basically says that they cannot be, and this is important, be excluded from the participation in, be denied the benefits, or be subjected to discrimination under any program or activity that we as school districts do. So before and after school activities, extracurricular activities, plays, athletic events, transportation, as well as classroom, field trips, everything that your son or daughter would want to access, we have to make sure that they have the opportunity to fully participate. And if their hearing impairment gets in the way, then we need to provide appropriate accommodations to get around that hearing impairment. That's really what the law means to you. Sometimes it's educational, Sometimes it's strictly access, and in your case, it's probably almost always some kind of communication to make sure that your child gets to fully participate in the classroom or the activity. And so that's kind of what it promises you. So then the problem, and for you, this is probably not as big a deal because most of the children we're talking about, as far as a disability, they meet the very basic definition, the first bullet up there. They have a physical or mental impairment, and that physical or mental impairment's documented in many cases from birth. We have audiological evaluations, we have communication evaluations, all which document the deafness or the hearing impairment. And so if your child in fact does have that diagnosis, has been determined to have deafness or a hearing impairment, and apologize if I'm not using the right language, I haven't gotten into the deaf community and talked about your disability enough lately to make sure I'm spot on, so if I say something that is not right, you guys can tell me I need to say something else. But the physical or mental impairment, in this case relative to the hearing impairment, meets the first definition of the disability of being eligible for a Section 504 plan or for special education. The second bullet is, does that physical impairment substantially limit me in any way? And one of the key problems we have is that just because you're deaf or you have a hearing impairment doesn't mean that that meets the test of a substantial limitation. And there's a 504 process in place, which we're going to talk about this evening, that's the district has to go through to determine whether or not the child with the hearing impairment is in fact eligible for either special education or for Section 504 services. Because just the disability in itself, the hearing impairment, may or may not be enough to cause a substantial limitation and require, in the case of special ed, specially designed instruction, in the case of 504 only kids, enough that they need accommodations to be successful. And for the simplest one is if I needed, for example, an FM system and I couldn't function adequately and get my education effectively without it, that accommodation might be one of the ones that he or she might need. They may not need any other instructional accommodations other than that, and so, but that could be enough in itself to meet the test of there's a substantial limitation. So as we go through the presentation and you want to bring up issues of whether somebody said you were or weren't eligible under either of the laws, I'll be glad to try to answer how they made their decision or at least give you the idea of what they were thinking about. But the bottom line for you to understand is that potentially any child with a severe hearing impairment is probably going to be eligible for, at a minimum, some Section 504 accommodations if that impairment's substantial enough that he needs it. And you as a parent don't have to worry about whether it's substantial enough or whether you understand that. That's the district's responsibility. And there's a process that you can use to sort of disagree with them or get them to reconsider if you think they made a bad decision. And I'll make sure you understand what that is also, because that's important. So once we've determined that your child, through the process that I'll explain to you, is eligible for either special ed or 504, then he's either going to get an IEP in the case of special education. As I understand, some of you probably got some discussions about IEPs in the past. If not, I'm sure there'll be some more trainings on IEPs in the future if you did miss that. And today we're talking about the Section 504 plan that your child might get if in fact he's determined to be eligible. So once he is eligible or she is eligible, the bottom bullet says what they get out of the law. They basically get to be provided aids, benefits, and services as effective as the non-disabled population. So it's not a Cadillac program, but it certainly is an adequate program. And so, and again, we're talking about not only academics, because it don't need an academic deficit necessarily to qualify for 504, but you do have to have some kind of access issues or support issues that without it you can't participate. So we have to create some problem that we need to solve with the plan. And that's what the evaluation process is all about. We'll talk about that. Any general questions about just the disability eligibility part of it? Are there any general question? If not, well, yes, ma'am.
Is it typically seen that a child that maybe has a hearing loss in just 1 ear eligible for a 504 accommodation plan?
She asked the question, you know, would a hearing impairment in one ear be substantial enough? I think, again, all these answers have to depend on that individual student and the evaluation that we go through. If you could make the case through the evaluation process, there was something that we really had to do, that he was really missing something or was losing access, then yes, and the team would be able to make that decision for you. And I think that one of the things we need to understand, there's no money attached to this. If the solution is something like he has 1 ear hearing impaired and somebody all of a sudden wants an FM system that's going to cost the district a substantial amount of money to do it, they're going to want to make sure they feel that the kid really needs it. And so we would have to look at our evaluation to determine that. But, you know, the audiologist, the people here at Children's, the other people who are working with your children could usually make the case if the kid really needs it through their evaluation and their contribution to our evaluation. And so that's the argument. And then, so there's always going to be, the interesting thing about 504 is there's no magic test you give for any of the disabilities, including the ones you guys are dealing with. So it is a matter of the team saying, we can see this problem and we need to address it. And so as a parent, if you can tell me, you know, and show me what it is about this, your child's impairment, that really needs us to do something in school, I'll probably buy it. I just have to hear it, I have to see it, I have to believe it. There's got to be something that I can observe or understand before I'm, as a team member for a district, going to say, okay, that makes sense to me, we're going to provide it. So, and so if you ever get into one of those, you know, debates and want, you know, the people here can help you, or, you know, you can call the ESD and we can walk you through it. I talk to parents all the time about issues where the district says no and they want to know, well, is that kind of reasonable or not? And I'll be happy to help on that individually. So the ADA amendments, I told you, the Americans with Disabilities Act amended the ADA in 2008. And really, I'm not going to spend a lot of time on this for you folks. I just want to kind of highlight some things. One thing, if you notice the last bullet, it really has required us to construe the definition of disability very broadly, and also to actually construe what I was just talking about with you, the substantial limitation, very open-mindedly and broadly. So I think it's going to, the intent of the ADA is to give you your best chance at convincing me as a district that there's something I need to do for your child. And if you can do that, then, you know, hopefully we'll be providing appropriate services. So I think the law's on your side a little more than it used to be. You know, it's always been pretty strongly on the side for this particular disability that we're talking about tonight. So if you're getting denied, I need to be talking about some of those denials tonight, and we can talk through them, because theoretically you should be getting pretty much the services you need out of districts, because they should know that they need to be providing them. Having said that, I never stood up in front of a group of parents yet and had them tell me the districts were doing everything right, so I'll try to walk through that. This is just sort of a graphic of the Section 504 special ed relationship. The big circle is all the kids in the school district. The littlest circle is the idea special ed kids only. And the sort of middle circle represents the 504 only kids. I would say that, you know, probably 90% of the seriously hearing impaired kids are in special ed. There's going to be a small percentage of them that will be 504 only kids. As they get older and as they acquire some of their skills in using interpreters and assistive technology devices, et cetera, a lot of those younger kids can transition to 504 and probably would get that service all the way through adulthood, maybe even into the employment arena. But that's just kind of a graphic for that. But let's just look at the implications. Now, you were talking about, you know, does this, one ear as opposed to both make a sense? These are the life activities there needs to be some substantial limitation on. And notice hearing and speaking are two of them. And so right off the bat, and this has always been there, this is not any part of the ADA amendments. So hearing and speaking and caring for oneself sometimes is related to hearing and speaking. And of course, working and learning are obvious. If we have learning deficits because of your communication problems, you're probably going to be in special ed for sure, at least get speech and language services, which is, again, going to probably put you in special ed. This is where it started to get expanded. Now it's getting into eating, sleeping, standing, lifting, bending, reading, concentrating, thinking, communicating. So the areas of impact got expanded even more. And so potentially, if we had a hearing impairment that affected some of these other areas of life, that could also be another argument where you could say, look, it seems like the hearing impairment's causing some issues that we need to address through an accommodation plan or a 504 plan. We also expanded it into major bodily functions. So the reason this was more relevant when I was talking to the staff here at the hospital a couple of months ago, because you start getting into the things that children have problems with other than hearing and blindness and mental retardation. There's a lot of bodily functions, there's a lot of cancer kids, there's a lot of kids with a variety of medical conditions that before sometimes were not being deemed eligible for services because it was just a physical problem. They were perfectly okay academically, they could pass their tests, but they had a physical problem that required some services at school, and sometimes we weren't providing them. So you can see that the definition is very broad. The other issue, and this kind of really does impact you, is that we're not supposed to consider mitigating measures when we decide whether you're eligible for services. So just because your child has a hearing aid or is using an assistive technology device doesn't mean he's automatically not eligible for anything. It could be that we still need to provide some things for him if he still needs it. Because we used to sort of say, well, if the kid has hearing aids, and then we're not going to consider him for anything. If he can hear, he can hear. We'll just make sure his hearing aids work. And there may be other things that the student still needs in addition to just having his hearing aids. And again, I don't know what those are. I'm sure you might. And so what I want you to understand is that because of this expansion, even the kids that have systems in place still may be eligible for services if there's still a substantial limitation in them accessing or being successful in school. And so that's a good thing from a parent's perspective. All of us in the district don't have the foggiest idea what this really means, however, because if I actually have a kid with hearing aids and he's doing great in school, then as far as we're concerned, we're done. And so, and we're probably going to keep saying that unless we can learn with families that there's some other things that could be in place that are going to make things more appropriate. But again, one of the problems you have with 504 as opposed to special ed is we're not trying to give your child the best program there is. We're trying to level the playing field and give them access. So there could be some additional stuff that you would really like to have and might make it an even better program, but they're probably going to say no to those unless they really think they're important. And you get to try to convince them in the process, and we'll talk about the process. Yes, ma'am.
So if a child has their own FM system at home, and they don't want to bring that to school, then would the school still be obliged to buy an FM system for the child?
Well, you'll have to tell me about FM systems. If it's something that could easily be provided, the kid could bring his to school, we'd certainly encourage you to do that. Districts are limited in resources. And the bottom line, though, is if he needs an FM system at school and he can't get it any other way, then we might have to purchase it. And we would have to purchase it. So again, but I want to encourage, and when we get to the process, I think we all need to understand that for individual devices, generally neither law says we're going to provide an individual device for you. We're going to make the school environment accessible for you, but we're not going to buy your individual hearing aids, for example. And with the cochlear implants, we're not going to do much of anything except once you have them, we might, if there's something we can do to make sure they're working or something. But, the cochlear implant thing idea, and everybody just said, we're not going to get into doing it. That's what the hospital does. So the individual device issue is that mostly we try to make sure if you have one, we know how to use it. We make sure it is used for you. If it's something that you can't afford or it's not transportable easily, then we could make the case that we need to do it. And I get the FM system all the time, and many districts have had to purchase them, so that's not an issue. In fact, what I learned from talking to a lot of folks, if we have FM systems in various locations, it's probably good for a lot of folks, not just the kids. So that one I think is pretty much a little bit easier sell. So I hope that answered your questions. If not, you can ask it another way a little later. I'll move on. Be happy to. The other one is that episodic impairments are now disabilities under the law if when they come, they're going to cause a significant impact. So if you had an intermittent hearing loss that kind of came and went, potentially, again, it might be that when you actually have it, there may be something that we need to do. So you may be able to make the case for some intermittent hearing loss that required services while it was in existence, that kid could be eligible for a 504 plan. But that's not a new issue, that intermittent hearing loss stuff, and we've, I think, in 504 plans in the past have probably had to deal with this. But I've been out of the direct field long enough that I don't know what people currently are doing. I do know that we had a lot of services in our district because we had the state school for the deaf. So I don't have a very good perspective about districts that don't have a lot of deaf services to start with, what they do or don't do when somebody shows up they're not used to dealing with. So. And temporary impairments the same way, and it's kind of the same issue for you. Again, this slide is probably more important for other disabilities than yours. Obviously, where we need to be concerned is when we have a child who's not doing well in school. And we have the obligation for all children, I don't care whether they have disabilities or not, to be looking at children and saying, well, if they're not doing well, is there a reason for it? And maybe one of those reasons is disability. And so this law has a child find obligation in it, just like special ed. And what that means is that the federal law says, under both of these laws, that if we suspect a disability, then it's our job to evaluate the student and determine if that disability does or doesn't exist. So if you had a child and you didn't know yet that they had a hearing impairment, but you started suspecting just because of the way he was acting at home and maybe what the teacher was telling him at school, then all of a sudden we have a suspicion of a disability. And if you have had that situation, you have the right to bring it up to the district and say, I think my child might have a hearing impairment. And we would have the obligation to look at the data, listen to what you have to say, talk to the teachers, and determine if we thought maybe there was a hearing impairment. So if we did agree with you that there might be one, then it would be our obligation to provide the child with an appropriate evaluation to determine if that hearing impairment existed, including an audiological evaluation and a speech-language evaluation. And so that's another part of both laws. So you don't have to already be diagnosed with a hearing impairment to have this law cover you. You could just have a suspicion that was legitimate, and then the district would have a responsibility of helping find out if that disability does or doesn't exist. That's the child find obligation. The other bullet that's probably relevant to you is probably the next to the last one, and that is, let's say that you, and it's probably for maybe the kids entering in early childhood from early childhood programs, let's say that your child comes in and is deemed not to be eligible for special ed services. That doesn't mean he or she may not be eligible for 504 services. So we have to look at the differing standards for eligibility. And the big difference for your kids, basically, is the need for specially designed instruction. If you need educational instruction, or you need instruction in learning to use an assistive technology device, or you need instruction in learning how to use an interpreter, those are all educational things that we would have to provide. If you need instruction in lip reading or in sign language, and we need to teach you that, that's instruction, and that's specially designed instruction, and that would guarantee you're a special ed student.
Actually, Ms. Rich, I'm Ann Curry, the Federal Way School District. I have a question about your last two bullets. It says, when a student is evaluated but is determined not IDEA eligible, we ask many students who come in who are deaf or hard of hearing and their eligibility criteria is determined under DD eligibility,
Yep.
rather than a hearing impairment at risk, which then bumps us down to that next bullet, when a student is identified as at risk, they're automatically not given a 504. And so what can you share with us about what the ESG is working on and OSPI? Because I know from my professional experience of working in developing statewide criteria to change eligibility guidelines, you still
Yeah.
don't have any integrity on that.
Well, you bring up the perennial DD eligibility category in birth to 3. And the DD, I'm a DD person that deals with developmental disabilities at the upper level, working with really children with cognitive disabilities, that DD. The DD eligibility category for birth to 3, 3 to 5 is an at-risk category, and it's very liberal. Now, there's going to definitely be kids. These two bullets are not designed for this presentation per se, so because it's for other disabilities. But for the disability problem you bring up, the kids are going to come from birth to 3 programs, and we capture a lot of at-risk kids, and it's okay under birth to 3. And then when they turn 3, we can still use that DD category up to age 8 in the law now. So they could stay eligible to age 8 with a DD label that got them in under hearing impairments. The issue is then we need to decide what services they need. So the eligibility category could stay DD to age 8 legally in our state under the WACs, under the special ed WACs. The issue, though, is the second part of the eligibility criteria under special ed. Okay, he's DD, but what is it that he needs? Does he need specially designed instruction or not? So when you take a hearing impaired child and kind of use what I was just talking about, if I have to teach him some things, that's specially designed instruction. But if really all he needs from 3 on, because we've really done a great job in birth to 3, is have interpreter services or his FM system or whatever, then maybe he would shift over and it'd be an accommodation under Section 504. So that's how I'd see the change. So age 8, then you have to make the hard decision in the WAC. Now you can make it earlier as a district if you choose to. You can take them off the DD label anytime after age 3, as long as you can come up with a legitimate category in the special ed regs. So if they can meet the criteria of deaf and hard of hearing in the special ed regs, you could shift them at age 3 if you chose to, or you could leave them till age 8. But at age 8, if he didn't make the criteria for deaf or hearing impaired in the WACs, then you would have to, in the WACs or the special ed regulations, then you would have to find another category, or potentially he may not be eligible. So even as a 504 kid, when he gets to age 8 and you're not using the DD label anymore, you could have a problem.
Okay, so to expand on that, so our kids who are coming in with a hearing impairment at age level and yet are not qualifying under the criteria for special ed would necessarily, am I correct, qualify for a 504 plan?
Okay. Given your evaluation and your team's determination as to what is the significant impact on learning, communication, speaking in this particular case, or some other access. So, and obviously, if the kid's still going to need an interpreter, if he's going to need an interpreter the rest of his life, maybe he's always going to make special ed cutoff in your district, I don't know. But say he didn't need anything else, and at some point, just an interpreter, like in the blind vision impaired area, just doing Braille for a student that's blind is not specially designed instruction. Teaching him Braille or her Braille is. So many blind children, who are very expensive to educate, by the way, may not be special ed for the most expensive part of their life, which is when they're in high school and taking honors classes and having everything brailled. They become a 504 kid. Districts don't get any extra money. So this law, I mean, we really have to kind of walk back and forth, and we have to look at I'm going to talk through the eligibility stuff some more, and I'll try to answer that again a couple of ways for you. Thanks. Great question. I'm not going to, the rest of this stuff basically deals with some other issues that we don't really need to talk about, except for the last bullet. Yeah, the last bullet is one that you need to understand. children who are special education and children who are under Section 504 plans have certain discipline protections under both laws, and they're sort of identical protections for the most part. And what that really means is that the kid can't get long-term suspended or expelled from school for disability-related behavior. So if I was getting suspended for some behavior that was a direct result of my hearing impairment, it would be illegal for me to long-term suspend or expel. Long-term suspension is more than 10 school days in a school year. So we can't keep kicking you out for some ramification of your hearing impairment. Now, I had enough experience in my state school for the deaf to understand that there definitely are behavioral issues in the deaf and hearing impaired community that are directly related to the deafness and the hearing impairment and some of the related communication issues, as well as some of the just relationships with other children because of the hearing impairment. So it could easily be that some of the children that we're talking about in this room at some point in their educational life may get into suspension issues that may be disability related. So as a parent, you need to understand that there may be some protections there, and the district may need to be working with you to come up with behavior programs to help the child with that behavior as opposed to kicking them out for that behavior. And so that's a very valuable thing for you to know and to use if you get into that situation. And I know we certainly had some children like that in the Anchorage School District. And I know every district that serves deaf and hearing impaired kids certainly has a small percentage of those kids that may have disability-related behavior that they need to be working on through behavior plans rather than just kicking them out of school for it. So that's the basic definition of disability. And generally speaking, you've got a pretty good case that if your kid has good documented hearing impairments or deafness, that he's going to meet the eligibility criteria as far as the definition side of it. Then comes the other part of it is there a substantial limitation? That's the part where the gray area comes in. And we need to kind of talk you through how that works. But right now I want to spend a little bit of time before I get there on special ed and 504. Because I want to make the argument in this room that if you have any choice whatsoever, my recommendation is stay with special ed. It's going to be better for your student, it's going to be better for the district, and it's going to be better for you as a parent because you have more rights. The district's going to get money to provide the services, so if there happens to be an expensive service, at least they have the opportunity. And in fact, in our district, sometimes we send deaf or hearing impaired kids to other districts for a deaf program. We're able to access what we call safety net monies, which potentially enables the district to capture the expense of sending the kid to another district for an expensive hearing impaired program. That's a great thing for you and for everybody. So special ed is the way to go. And if you don't want special ed because you don't like what's happening in special ed, the solution is to work with the special ed folks and figure out what we're doing wrong and try to get that fixed rather than say, well, I don't like special ed, they're not doing it right, I want a 504 plan. You have the right to get out of special ed, you can always say no, but I'm just suggesting to you that there's a lot of benefits for you. And here's the first reason. The first thing is that both laws require a plan. However, in special education, that plan is much more detailed, and you are a powerful member of the team that develops the plan in special ed. And as the second bullet says up here, in 504, the parent is not even a required member of the team that develops the plan in 504. Now, that doesn't mean most of us don't involve parents in developing 504 plans, but the letter of the law says I don't have to. And so what that means is you don't have as much sort of clout in the 504 process as you do in special ed. Much better to be on the IEP. We recommend, and all the training I do across the state, you know, we're obviously saying we want parents in the process. We want them invited. We want them to participate. You are going to have the right to give us permission to do everything. You have the right to give us permission to do the plan. We can't do the evaluation or the plan without your permission. So I don't mean that you don't have any authority there. And you have the right to some other things that I'll walk you through as far as rights. But the basic assumption in 504 is that the team is the district's sort of primary responsibility. and we want to listen to you, but the district really gets to make the decision. And so sometimes parents will feel like they don't quite have as much say. And the fact of the matter is they don't in the law even. Special ed, you're an absolute required member. We have to go out of our way to involve you. You have a lot more power in the decision making. And like, for example, in ID of the special ed law, we basically say, and we have to, by the way, use the communication system that the family wants us to use. I can't just say my district's a C-sign district, that's what you get. So the ASL, C-sign, all those different lip reading, whatever communication system, we wrote into special ed saying we have to honor that across the IEP table. 504 doesn't necessarily say that. And so that's why you want to make sure you do that. The rest of this, I'm not going to belabor. I already talked about the third bullet, which is basically there's an assumption that the 504 accommodation is going to be something that other people do besides special ed. General ed people do it, not special ed folks, and we can't use special ed money. So that's a big difference. Yes?
Just a question. One thing that's been my experience is that the level that the district is willing to work with you under IDEA is very dependent on the district as well, because we've had our issues with Seattle School District, and even though our son is covered under IDEA and we have more rights, apparently no one told the district that.
Well, I don't know what to say about that, except to say that we, at the ESD, we try to work with all our districts to encourage them to work as collaboratively as they can with families. The law is the same in every district, and I certainly get questions from parents from some districts more than other districts, and it definitely is an issue. And I know, I'll just be honest with you, I have a real problem with Seattle School District and Section 504 implementation. And they have not used me at all historically, probably one of the few districts in the state that haven't. So I know that, it's been a little difficult. However, I've just talked to an attorney that's starting to do some work in the district and is definitely working on that 504 issue for the Seattle School District. So I had a kind of a personal issue with an attorney there, but that's been resolved. And I think you're going to see the 504 side of the equation improve in the Seattle School District. So, and I hope so. But again, if I'd never go away from one of these trainings without somebody following up with questions for me. If you get an individual issue, whether it's in special ed, because we do this at the SD, we answer family questions on special ed or 504, and you think something I said, they're doing it a different way or you don't understand, feel free to call me and we'll talk you through it and give you a person to talk to and try to help it get better. So that's part of what we do at the SD. So those of you that know the special ed process, this is the 504 process, sort of the steps, and I'm going to walk you through what the parent sort of relationship is and what you should be thinking about in each of these steps. The first one at the top was that child finds suspicion of a disability. The only thing you need to know about that is if you have a suspicion that your child has a disability and it has not been addressed yet, you have the right to ask for an evaluation from the school district. And we have to either evaluate your child, or we have to tell you why we're not going to evaluate. And the only reason I would not evaluate is, let's say some parent just decided their kid had a hearing impairment. And they said, I think my kid has a hearing impairment, I want you to evaluate him. And I talked to the teacher, and I talked to everybody in the school, and I look at the kid, and I go, I don't see it. And I'm not going to evaluate him. I don't see it. And when I say that, however, the law says I will have to give you in writing a statement to that effect that says, you asked me to evaluate, I'm not going to evaluate him. And I'm not going to evaluate him because I looked at this information and I made this determination. Now, you could take that document that I give you and you can take it to an advocate of any kind or an attorney, and you can say, hey, I still think my kid needs to be evaluated. And you have procedural safeguards under both special ed and 504. and you could ask for a due process hearing, and an administrative law judge in special education would hear the case, and then you might decide that we were all wet and the district needs to evaluate, and they would tell us we'd have to evaluate. You could do the same thing under 504 and get a hearing officer to make the same decision. So every decision that I'm going to talk about on this flow chart, you have the right under 504 and under special education to ask for mediation, which is free, and it's a matter of getting some more meetings with the professional mediator to try to resolve it. Or you can ask for a hearing, which is a legal, basically, trial, where somebody hears the case that's totally independent of the district and says, parent's right or district's right. If the district's wrong, if there's attorney's fees attached, the district gets to pay the attorney's fees, including yours. So even though the hearing process costs money, potentially you'd be held harmless expensive-wise. However, I do not recommend anybody going to hearing on any event. Mediation's there. That's what we're here to do, to try to help you. We want to work together with districts. It's going to cost somebody a bunch of money to go to hearing, and most of the solutions we're fighting over don't cost nearly as much as it does to pay the attorneys. So it's not a good process. I've been through two myself in my district. Both of them were devastating to families and to staff. And I really wished I could have gone back and undone them because they were not helpful to the kid, to the family, or to us. And they cost everybody money and a lot of heartache. So we don't want that. But you do have the right. And sometimes I have to tell you, do it. And I will tell you that in a 504 issue, I became an expert witness against one of our districts because I kept trying to work with the district and found they wouldn't work with the family. I said, okay, if you won't do this, I'm going to be on their side of the equation testifying against you. And so, we at the ESD are more than willing to help through some of that. Once we decide, however, that there's a suspicion of a disability, then we need to get the kid into the referral process and get an evaluation. So this is the second point in time where you as a parent have the right to say yes or no. So if I say to you, well, we've decided your kid has a hearing impairment, we want to evaluate them for either law. Before we can do anything, you have to give us permission. If you don't give us permission, we're basically out of business. We have to stop. Now, Section 504 is different than special ed in that if we chose to, we could take you to hearing and have a hearing officer say we're going to evaluate. But no district ever does that because if you don't want us to do it, there's not much percent in us, getting some judge to tell you to do it. Because you probably just move out of the district if push come to shove. You're not going to let us do something you don't want us to do to your kid. But most of you want the services. That the debate usually is not we want to evaluate, it's you want to evaluate and we don't think you need it. So it's usually the other way around. So once you get consent, you give us consent, then a clock starts. And we have a certain amount of time to get our work done. So one of the other things you need to understand is that once you give us consent for evaluation, we shouldn't be taking all school year to determine your kid's eligible and give you a plan under either law. There's very strict timelines in special education, and basically the Office for Civil Rights uses those timelines for 504. So the 35 days and all those days that are in special ed law, and you can get those out of the whack, and I can talk to you about them. And just know that if it starts to feel untimely to you, it probably is. And if we don't do our work in a timely manner, you can complain to OSPI for a special ed kid or OCR for a 504 kid, and they will take the complaint, they will investigate, and they will tell the district to get on with it if they're dragging their feet. So just know that. Once we get the referral going, you've given us permission, then the next step is we have to convene a 504 evaluation team, just like a special ed evaluation team. But the 504 team doesn't have as many strings attached to it as the special ed team. It really needs to have three types of folks at the table. It needs to have somebody who's knowledgeable about the student, somebody who understands the disability, and somebody who's like an administrative designee, understands the placement options in the district and can commit district resources. And so in 504 teams, the person that understands the disability for deaf and hearing impaired kids could be one of our deaf and hearing impaired teachers if we were a big district and actually had a program. It might be audiologists that are in the evaluation process that understand. It might be speech and language pathologists. There's a variety of folks who might represent understanding the disability on the team. And it could be a deaf educator, obviously. Could be a school psychologist that's looked at the evaluation data and understands it. The person knowledgeable about the student can be the classroom teacher, or in many cases could be you as the family. There's nobody understands the kids more than you. So you would be a legitimate member of the team and could represent, if I chose to have you as that part of the team and wanted to use you in that role, I could use you as a district. I could also say, I'm going to have this person, I'm going to have the classroom teacher there to represent understanding the kid in school. I'm going to have you there as a parent because I want your feedback. And then I'm going to have somebody who understands the disability. So you could be a part of the team in addition. Or it could just be you and a couple other folks. But it has to be a team. So another thing that you want to make sure happens is that all the decisions that we make, the right people are at the table. And so if you have a question, if they invite you to a meeting and you don't think the right people are there, ask them, what role are they playing? Who's here that represents knowing my kid? In special ed, we have to involve the general ed teacher. And so you may want to make sure in yours, even though we don't have to involve it in 504, you may want to ask, who is the teacher that knows about my kid in school? Because that would be helpful. And so those are the three folks on the evaluation team. What does the evaluation team do? Their responsibility is to either personally participate in doing the actual evaluation, doing the audiological, doing the psychological, doing the speech and language evaluation. Those may be part of the evaluation team. Or it could be that we're taking stuff that you're bringing to us. For example, if you put your children through Children's here and they came out with diagnosis and evaluation reports that we could use in the school district, you might actually bring them to our team, and our team would not do any assessment. We would look at the data and we would look at the school and decide. So our real evaluation actually would be looking at what Children's provided us as far as all the evaluation reports and looking at their recommendations, looking at the kid in school, and then saying, yes, he's eligible, or no, he's not eligible. So sometimes in 504, we don't actually do the testing. Special ed, we almost always do the assessment ourselves. Most of the time, we don't have a total assessment that we can work from. Go ahead.
It sounds like this doesn't start until after the school year starts, which actually makes me nervous, because if your child is going and you know that they aren't necessarily going to be one of the special ed kids, but you know that they're going to need a 504, there's this potential to miss like 30 days of their kindergarten education a little bit. So is this something that if we know it's something we're going to need to pursue, that we can pursue prior to the school year starting, or do we really have to wait until after?
No, you do not have to wait. You do not have to wait. If you have a suspicion, and for young kids, I recommend, and I've had parents doing it all the time. They would call me up in Anchorage saying, we're moving up. I had a lot of military, because I had two bases like here, Air Force and Army base, and they'd be calling me saying, we're moving up next September. And, we're putting you on notice. We have a kid with a disability or suspect, and we need an evaluation. I said, well, if you get here in August, or July or August, then we can do an evaluation and be ready for the day one in school. Under the birth to 3 to 5 area, we have a WAC mandate that says we have to have the IEP in place on the third birthday. So if you're coming from birth to 3, then we have to have the plan in place by your third birthday. So you start off day 1. Not the day after, by that day. And if not, then we're a non-compliant school district. And as an ESD person, I get to go around and say, why did that happen? Fix the problem. You're not communicating effectively with the families or the early childhood folks. So definitely if your kids are coming from the birth to 3 to the 3 to 5, you need to be on target.
My question then is, if a child's gone through birth to 3, is deemed ineligible for an IDA kind of special ed placement, and still is at risk, and the school district is not considering a 504 plan for someone who's turned 3 and nothing is in place, what do we do about getting that 504 for that preschooler?
Well, the only way you're going to do that is to convince the 504 team that there's a legitimate disability. And Section 504 doesn't necessarily honor the DD label like IDEA does, so you're going to have to find a legitimate disability. So it may be a communication problem. It depends on what it is you think that kid would need. You're going to have to try to come up with a disability. Now, what I recommend to districts as far as a promise and practice here is that when you do the IDEA transition kids from birth to 3, you need to look at 504 at the same time. But the fact of the matter is, the 504 actually doesn't apply until kindergarten. So there's a gap of 3 to 5 if the kids, if the district doesn't provide other services. So there's potentially a problem in the 504 law that says you could have a gap of service from 3 to 5 if you can't find a legitimate disability in special ed.
So to summarize that for all of our parents, if their district doesn't have preschool options
Yeah,
and they don't qualify for an IDA, special education IEP,
right.
there's a very high probability, am I correct, that they would not get a 504 in their own home district?
Potentially, yes.
Thank you.
Especially if they're a smaller district and don't have a lot of services. I don't know what a lot of the districts are doing. I have not been close to birth to 3 and 3 to 5 in a long time. My partner Val has at the ESD. So if you get into one of those questions, you might want to have call our ESD and talk to Valerie Lynch, who is at the same office I am at SBI, and she can talk you through that. But there is a gap in services in that for a 504 only kid, the 3 to 5 year old area does not apply unless the district provides early childhood services to gen ed. It's only kindergarten on. So you could have a gap from birth to 3. And as soon as you brought that up, it just dawned on me that that's just an issue that there's no legal answer for. There's no solution to it. Thank you.
Does that mean like a kneecap program or a Head Start program? If a child enrolls in Head Start and they're 4 years old, are they eligible for 504 then if they can find a disability, document a disability?
Well, again, if they're in, if they're in the Head Start program or the ECAP program and it's 3 to 5, again, if they want any special ed services, they're going to have to be eligible for special ed. 504 again is not going to apply until age 5 or kindergarten age, whatever that is in the district. Yeah.
And so then if the child is coming into kindergarten in fall and the family already knows that they're not eligible for special education, you're saying that that evaluation process should begin in the summer?
I'm suggesting that this is just a parent advocate comment now. I'm suggesting if you know your kid has legitimate issues that are probably going to need to have, that you believe are going to need to have a 504 plan, I would refer my kid for an evaluation prior to the opening of school. You're probably not going to get too much out of it, but a conscientious person will do it. And some people will do it, some people won't, depending on your district. And OCR is not going to do anything. They're going to start the clock rolling probably on the first day of school. So potentially you could have the problem you brought up in your question. But I think most of the folks I know, people are very committed in most of our districts to their early childhood programs and 3 to 5 programs. So I think I would, if I in my district, I'd try to make good friends with the 3 to 5 folks and try to see what I could, get going for my kid ahead of time so there wasn't a gap in service. And then if you can't do that, then the best thing is know the time frame, put them on notice you're going to hold them to it, and get on with it. But I will also tell you, in a lot of cases, I think, it may or may not be that detrimental one way or another. It may be worthwhile getting in school and doing some things anyway. So even though I love everything to be started right at day one, it may not make any difference. It's not worth getting an ulcer over. We got lots of time. But the other issue, though, is we have to be accountable. And so there are timelines. If you feel like they're dragging their feet, call them on it. And in either case, if you feel like the district is not doing the law that I'm saying here, not that they're not giving you what you want, but that they're not evaluating in a timely manner, they're not evaluating when they think they should evaluate, and you can't get any action out of them, you can file a complaint with OCR, cost you no money, file a complaint with SBI if it's a special ed issue, cost you no money. They will investigate and try to get them moving fast. So sometimes you need to do that. Other times you can call one of the ESDs and we also work as a facilitator to try to crank people up. Just like if you brought me an early childhood issue on deafness or hearing impairment, I'd probably talk to Val, and she'd probably be talking to people and trying to see what they could work out, if there were solutions to it. Yes?
One question I have is about evaluations, in that it seems like, in my experience with our child, the means that the school districts are using to evaluate the children are often very subjective. But when you're asking for stuff, the school district will ask you for very scientific stuff. You know, your impressions and words aren't necessarily considered objective to the school evaluators. And there doesn't seem to be a lot in the way of resources out there to identify real objective means to identify when particular types of accommodations are needed. And it seems very arbitrary to me who chooses what within a school district for which accommodation.
Well, interesting enough, that just kind of brings me down to the once we've said that the kid has a disability and there's a substantial limitation. Now that's arbitrary too. How substantial is substantial? That's hearable under a due process hearing if you think I made a dumb decision. And you know, that's one way of solving it. Hopefully we'll be on the same page more than not, but if not, that's how you get around that. If you think, I think it's substantial, the district said no, and we can't mediate it, we can't talk about it anymore. The procedural safeguard of asking for a due process hearing is where an independent person, not the district's employee, and has the skills to basically, and the understanding of the law, would hear the case. You'd make your case, they'd make theirs, and the hearing officer decide. Once we get to the next step of doing the accommodation plan, you're absolutely right. You know, there's books of accommodations out there. A parent can go on there and Google and get 10,000 accommodations for any disability you want to dream up. And that's the problem. There's no objective, scientific criteria for a whole lot of them anywhere. Doctors don't have them either, by the way. I get ADHD diagnoses with doctors giving me strings of accommodation recommendations that I know they took out of a book. Probably the parent brought them in and the doctor signed off on them sometimes. I hate to say it, but I know it's true. And, then we start fighting over it. And the issue is that this team, the 504 team, and OCR expects, the Office for Civil Rights, expects our team to look at the data. We have to do an appropriate evaluations. So between us, what the doctors give us, that's the stuff that we have to really do appropriately. The accommodation decision is very much a give and take thing that we need to look at the options out there and pick accommodations that we think will make sense, that are cost effective and will do the job. Now, there's no answer about, there's a concept that sometimes districts will use with you, say, well, that's not a reasonable accommodation, going to cost money. Well, OCR already said there is no such word as reasonable accommodation in the law for kids. There is in the law for adults in the employment world, but not for us as kids. So your team, and you're most likely going to be part of the team, has all of the accommodations on the table that anybody can dream up that makes sense for your particular son or daughter. Then we have to sift through those and decide which ones we're actually going to do. Now the district in the end gets to make the choice, and they're going to propose to you in the end, this is what we're going to do. And again, that due process hearing kicks in, or mediation, and we can fuss about it and try to come up with it. My suggestion to families, however, is this, and I've said it in special education and I say it in Section 504, where we usually get in trouble with families and districts is within one side or the other goes in with their mind made up that the only solution to my problem is this service or that, or this much service or that much service. And when a parent walks in and says, the only thing I'm going to agree to is an hour and a half a day of physical therapy or speech therapy or whatever, and they sit there, well, there's probably going to be a problem. So what I encourage everybody to do is to be open-minded about the discussion about accommodations. Try to base it on as objective a data as we can get, but there's always many solutions to each problem. So one of the things I really recommend is not only that the team get involved, but the classroom teacher is going to have to implement it, be involved at the table, and we talk about them. So if we say, if you can clearly tell me what your son or daughter's problem is, let's look at what are possible solutions. And then let's pick out the ones that make sense that we can do. And obviously, as a district, I'm still going to, if I got one that costs this much and one that costs this much, I'm going to pick the cheaper one because I don't have a blank check here. So but if you think it's not going to work, then we're going to be at impasse. What I suggest either the district or the parents do in those impasse situations is, if one party or the other has something on the table, try one of them for a certain period of time. So, and I tell parents the best way to get around the district's objections, if they want to offer you an accommodation that you don't think is going to work, and we don't want to have the big battle and go to hearing yet, say, okay, I'll let you try that accommodation for X amount of time, and we're going to establish some criteria for whether it's successful or not. And we're going to agree on whether it looks successful. We're going to put that in writing. We're going to implement it for X number of days or weeks. Usually not days. You got to do it almost a certain amount of time. Then we're going to have another meeting, and we're going to look at the data. And we're going to collect data to see. If it works, you should be happy. It worked. If it doesn't work, now you got an argument that they just proved for you that it didn't work. Now your option's a lot more viable. So sometimes that strategy is a way to get us off the mark when we're fussing over stuff. But I think, again, if you can explain your child's problem clearly to us, most of us are going to want to try to solve it as best we can. So I think sometimes we don't spend enough time in the evaluation process and the discussion of the kids' performance levels to get at a common understanding of what the kids' problems are, and then we don't come up with good solutions. So I think that's another important thing to consider. Once we come up with the plan, however, before we can implement it, we have to get your permission. And you give us permission, we implement it. If you don't, we don't. And so that's kind of where that goes. Following the plan, we have to then implement it. And one of the big problems you'll find with 504 plans and IEPs, and I'm sure you will tell me that, is that we write this beautiful plan, then we don't do it. Well, don't ask me why that is, because that's embarrassing to me as a professional special educator. But the most common complaint that goes to OCR, Office for Civil Rights, or OSPI, Superintendent of Public Instruction on special ed side, is that parents file a complaint with them and say that the district didn't implement the plan. The data for the last 10 years that I've looked at says that in those cases, parents win more than they lose. Almost 60-40. That's criminal from my perspective. If I write it, I should do it. So one of the things that you'll always get from me if you ever called my office, I said, do you have a plan? Yes. What's it say? I listened to it. Now, did they do it? No. Call the district. Here's what the plan says. Did you do it? Show me how you did it. And if they can't show me, they lose. And that's as simple as OCR's or OSPI's complaint resolution goes. And it's very sad. So one of the things that you want to do is have a check on whether it's happening or not, and most parents do that. But try to build into the accommodation plan some sort of data or report out to you so you know whether it's happening or not. And in special ed, we have to report out our progress at least quarterly. And so I would say to you, ask for some kind of at least quarterly report on successful implementation of the plan. And so that's there. And then you have one other fail-safe, and that is we also, in the last box up here, have to at least annually, once a year, once a school year, look at the plan and make sure it's okay, make sure it doesn't need revising. And so you should be contacted at least once a year from the district saying, how's it going? Let's talk about it. Sometimes we meet, sometimes we don't. OCR doesn't care, 504 doesn't care whether we physically get together. If we can call and talk on the phone, you're happy, I'm happy, teacher says everything's going all right, your kid's still, we can say, okay, we're going to re-up it, keep going. Or we might say, no, we're going to tweak it a little bit, so then we revise the plan. And if we're going to revise it, then we need to get it in writing and make sure you have a copy of it so you know what to expect. Okay? Any questions on the process? Again, your rights in this process are every decision that we make, yes or no, whether it's yes to evaluate or no to evaluate, yes, you're eligible, no, you're not eligible, here's the plan, take it or leave it, you get to say yes or no in each of these cases. And if you disagree with any of our decisions, we're going to give you in writing why we made our decision, and you get to challenge us if you wish to through mediation or a hearing. Jim.
Having the opportunity to work with multiple districts in collaboration, I've noticed that there's a great discontinuity between what's called professional judgment on eligibility and determination for a IDA or a 504.
Yes.
Can you answer to that?
Well,
Professional
there
judgment.
shouldn't be that much professional judgment in special ed, because there's really a very limited ability for us to use professional judgment. It's been overused. A 504, there's a lot of professional judgment in 504. In fact, OCR doesn't care if you over-identify, because they're not giving you any money anyway. Special ed does not want us to, because they're very rigidly monitored by the feds, and we're giving out money. So OCR, though, really expects us to still do as a professional a job in evaluating as special ed, and we're probably seeing OCR finding more districts in non-compliance now about not doing as good an evaluation as because they've been kind of loose on it. Kind of get together, talk about it, say yes without any real data. And so that's important that we understand that. There's also some words that you'll read about if you ever picked up the 504 law itself and read it, it would say the first bullet I had has a physical or mental impairment that substantially limits a major life activity. That's the real definition for kids. The other one is perceived as having a disability or has a record of a disability. So for a long time, people thought, well, if mom perceived the kid has a disability, we're going to make him a 504 kid. That's not true. That's not the law. And just because I was a 504 early childhood kid, again, doesn't make me a 504 kid once I'm in school. We still have to go through the evaluation process and make sure you're eligible. So, any questions about the basic process? Okay. When we talk about accommodations, again, you can't go to the rules and regulations in 504 and find any definition. So basically, an accommodation is anything that we can dream up that we think is going to get around the problem we identify that the kid has. So if somebody says that's not an accommodation, I don't know what they're basing it on. Now, they might say, I don't want to do that accommodation. That's legitimate. But to say, well, that particular thing isn't an accommodation, it might be that it's specially designed instruction. And so sometimes I spend some time talking about what the difference between a 504 accommodation is and specially designed instruction. And for your purposes, I think the clearest thing to get a distinction is that and your kid is going to be in special education if he needs specially designed instruction. And that means the key word there is instruction, and instruction based on the disability, and instruction to try to help the kid learn something relative to his disability. In most cases, we're not ever going to cure a disability, but we're going to teach compensatory skills. So in our case, we're going to teach you how to access sign language. We're going to teach you how to use your assistive technology device, your FM system, whatever it is. That's instruction. And so that may be time limited in that once I teach you, you don't need any instruction anymore. But I still need the interpreter, or I still need the FM system. Then it shifts from specially designed instruction to just accommodations. And so the provision of accommodations is really what 504 is about, not the instructional piece. That's going to usually get you special education. And when we talk about accommodations, there's a variety of areas. We can talk about instructional arrangements, and again, lesson formats, the curriculum, a variety of things, but modifications of the physical plant. For example, the FM system is kind of a big modification. And then, for example, some of the things that the hearing impaired folks shared with me that are common that we may be considering in this particular arena are a variety of things like preferential seatings, which is not just sitting in the front of the room, by the way, and we know that. And so we need to make sure people understand what that means if they're going to do preferential seating, how and what we're going to do with the FM system. So making that decision we talked about, whose FM system, if there's a possibility of the kid bringing it, are they going to bring it? If not, what are we going to do about it? It's kind of like a child with the orthopedically impairments. You know, we're not going to buy his wheelchair for him in special ed. But if he comes to school with one that he doesn't leave at school and he's at school, we're going to have to provide a loaner while he's in school. So we end up in funny situations with some assistive technology devices where families don't bring them to school and we have to supply them. The whole issue of note takers, interpreters, transcribers, I think this is where you're going to get into some fussing with districts sometimes, because just my limited understanding of these variety of services is that some of them are definitely more expensive than other ones, and so I think we're going to be debating about that sometimes across the 504 discussion table as to whether I really need the best one or not. And OCR is not going to say you need the best of anything, but they are going to say it has to meet the kids' needs. And so there's another example of sort of that objectivity. We need to make our case, and hopefully good minds will come up with something that kind of works. But the bottom line is if we could convince a judge that he really needed the most expensive system in the world, then the district would have to provide it. And we know that because of the Supreme Court decision. It said, even if you need a full-time nurse, 100% of the time you're in school, sitting beside you all day, district have to do it. That was a Supreme Court decision. That's about as expensive as you're going to get. But they said he needed it. And what he was a very severely orthopedically impaired, medically fragile kid who was smart as a whip and could go to school and learn everything. But he was very fragile and had to have all of this support around him at all times to be safe. And then he had a lot of assistive technology stuff too, which he could do. It was just that nurse, that was easy. You just buy it, train him, and he used it because he was very intellectually capable. But because he was intellectually capable, that caused all kinds of grief as far as all the kind of things the district had to do to support him. And we have the same thing with deaf kids and the same thing with blind kids who are very talented and need interpreters and need brailing and need a variety of accommodations. Any other accommodation issues that have come up? We've mentioned the FM system. Are there ones that you've had trouble talking about or getting, or issues about accommodations? Any questions in that arena? Sir?
Well, the one that we're dealing with is trying to get cued speech support.
Cued speech?
Yes.
Okay. And again, I can't answer from the kind of communication systems that are out there, but you certainly have the ability to ask for that. You certainly have to consider it. And I don't know, so you guys that know deaf education better than I do, talk to me about from an IDEA standpoint, from a special ed standpoint, we have to look at the communication system of the family. Is cued speech one of those that we consider in IDEA? I don't know, because I don't know exactly what it is.
We recognize it in the state of Washington.
Okay. Okay.
Oftentimes we'll have families move into the state from acute speech educational system
Okay.
and have a very difficult time finding access to speech supports and/or trained teachers.
That's the biggest problem. That's the biggest. Yeah.
It's just rare to
Yeah,
find.
we have to consider it, and then we have to do our best to work around it if we can't provide it. And if you get into a smaller district or a rural district, it's almost guaranteed you're going to have trouble with that. But know that the law's there, and you certainly have a right to discuss it. We have to see if we can work around it. One of the problems we run into with both special ed and 504, it's just like interpreter services. We want to have a certified interpreter. But when you get where you get, and I was in Alaska, when you get into rural Alaska, it's just not going to happen. So paraeducators getting some, cram courses and being able to communicate as effectively as possible may be as good as it gets. And I guess the solution to that is if we really have somebody that needs it, that may not be where we can live if we really want something for our children.
With the note taker piece, some of the older kids I worked with, that was deemed that it was okay just to have another student in the class take notes and then on a card of paper and give it to them. And for some kids that works, and for some kids that didn't work. And would a district ever actually pay an adult to come in and do the notes for the class, or?
I think if you use sort of the logic that I shared with you earlier, okay, you propose that, let's try it. If it's working, great. If it's not working, then let's discuss some other options and see if we can get, maybe the kid needed training. So maybe I need an EA, an educational assistant that has more skills at note taking, because they do that for some other kids too. And another thing is that we're seeing is that what I'm finding, especially in a lot of secondary schools now, there's starting to be a lot of good note taking that goes on by talented kids who get the notes for everybody if they need it. So it's a service that's actually happening for not just not even just disabled kids.
Have you ever seen anyone ask for a whiteboard as an accommodation? The board.
I'm not sure, but I'm sure there probably has been asked for. Have you guys seen that?
Because then you can, if the teachers write on the whiteboard, they can email that out to the students.
Well, I'm seeing a whole host of accommodations through assistive technology. We just had some people doing some training for us at the SD, and there's such a wide variety of great gadgets out there now that I think almost anything's worthwhile asking for. We need to look at it, find the options. There's resources out of the University of Washington in the assistive technology stuff. One of my good friends, Kurt Johnson, works here. And he just sat there with me and went through a whole bunch of stuff that I'd never seen in my life. That's just going to have a spectacular application. So yeah, and a lot of districts are looking at it. And currently, on the special ed side, especially for the next 6 months, we have some money as far as good assistive technology devices, and so there can be some situations where districts are willing to put some money in it, because we can't use a lot of that money just for people, and so I know a lot of districts have tried to really take their assistive technology with the ARA money from the federal government and try to beef up their opportunities. So again, I think if you make it known, at least people can consider it.
We installed a Promethean board, which is a smart board for one of our deaf and hard of hearing classes. That's an accommodation, and it benefited all the students.
Absolutely.
It's part of the general ed assistive tech for some teachers who had applied for the grant. And when we did it, we found out how much easier all the students access general ed curriculum through this same kind of technology. It was quite remarkable.
I would actually suspect that technology is going to be more common in every classroom, because it's so effective for doing some of the stuff that is very expensive the old way.
Our new schools are putting them all in every classroom, built that way.
Right.
Quick question.
You bet.
So the 504 plan can be modified annually. If an emergency situation comes up for a situation that wasn't foreseen at the beginning of the school year, my daughter wears a hearing aid in only one ear. Her hearing aid is now gone. It's being sent out for repair, and we don't have a replacement for her. So can I go in and ask for a modification to that 504 plan right now, this week, if I know that that's something that's
Yeah,
going on?
absolutely. And one of the real misconceptions, in fact, when I first got down to SPI and was working at the state, in the special ed superintendent's office, I kept getting these questions from parents of special ed kids, and they'd say, well, my district told me my IEP's not working. Okay, I said, okay. Do you have ask them for an IEP meeting? Well, they told me I only could have one IEP meeting a year at the annual review. And it was common practice when I got here in 1992. And so many times people will tell you, well, you have to review it annually. That's the law. You can always review it if it's not working. Just like if things are really not working, you can ask for a reevaluation to find out, let's do some more testing. It's really not working. And so a reevaluation, even though that only has to legally be done every 3 years in special ed to determine you're still eligible, it can always be requested by a parent. Doesn't mean I always have to do it, but you have the right to request it, and you have those procedural safeguards to back you up if you can't get me to do something you really think is crucial. But in your case, absolutely, and you should ask for that. And if it's not working, when you're asking for the feedback on, say, quarterly reports or whatever you've agreed to with the district on the accommodations, if it's not looking good to you, call the district and say, we need to talk. Let's get together. And don't take, no for an answer. Say, no, we have to meet. Because I want to talk about this. And then if they don't, then we have to go through some other business with them. But that's when you call somebody like a district office and say, hey, they won't meet with me. And all the districts have a 504 person centrally in the district, and usually they have a specific one in your building. You can always go to the principal to start with, and should. If you know the 504 coordinator in the district, a lot of times it's counselors, you could go to them if you're having a 504 issue. And there's always a central office person that has something to do with 504. So there's people to go to kind of get the system going if people are giving you funny answers like, we don't have to do it except once a year or something. Thanks for bringing it up. That was a good point.
I wanted to mention, do you realize you could ask your audiologist for a lower hearing aid too, for the interim?
She only has one that goes in her ear. She doesn't have one that goes over her. Yeah, and we tried several donors on her, and it wouldn't work. Yeah.
So what kind of hearing aid does she have that you
She
can't
has
get?
one that goes in her ear,
Oh.
but it doesn't go over.
So you
It's
can't.
custom made to
Yeah,
fit
so
the
you-
class area.
So what normally happens in that situation then?
It's been a struggle this week for her. She's having a really hard time.
Oh, yeah.
And the district is telling me that they do not have to provide any accommodation for her. Her school is telling me that they, nothing, she's not a special ed student. We don't have an IEP, we only have a 504. And they won't make a modification for an FM system in the classroom. They simply won't do anything because it's a temporary situation that's only gonna last. Next week is midwinter break. We have 3 days left for this week and then,
Well, and I think that, if the district didn't have an FM system, they're probably not gonna do it for 3 or 4 days or something. But if there's some other kind of accommodation we can dream up to help her, we need to do it. And we have an obligation under 504 to do it too, just like special ed. Okay.
You're managing audiologist, Pam, so we
Yeah.
have to hook you up with a loaner FM system,
Yeah,
so please explore
thank
that.
Yeah.
you.
yeah. What district are you in?
Eyeline.
Okay.
Oh.
Yeah, call them. Yeah, I definitely call somebody there. You can get some action out of that. I promise you.
Thank you. Maybe
Oh, I was just gonna
I'm
say, so
sorry?
I am an audiologist, here at Children's, as far as your 504 plan, and you might be able to tell whether this is appropriate or not, but it sounds like there needs to be a fail-safe, a backup, and
Yeah.
that if her hearing aid does go down for repair because she
Yeah.
cannot accommodate an ear level, which is
Yeah.
what most loaner hearing aids are,
Right.
maybe they need to have a portable desktop system available to her. And Highline is a district that has a large number of hearing impaired kids, and I think that, I would think they have the technology.
Okay.
Anyway, the second is that, with your child's audiologist, to really maybe come up with a backup plan. Maybe you need to expedite the repair, maybe you need to try harder to find a hearing aid that will work. And then there are loaner FM systems. We don't carry the desktop kind of sound field ones here at the
Sure.
hospital, but we do have your level ones that we can loan from.
So again, I think that given you're in a district that's big enough that it actually has services, I would try to get to those people and talk about solutions. There's almost always in a program like that, you got one of the audiologists that's an advocate.
Yeah.
And everyone I ever was involved with had one that would help us solve the problem.
So is another option to get an ear mold made for that ear, so that
Yes.
when your own hearing aid needs to be repaired, they can fit her with a hearing
Right.
aid that goes behind the ear. And the only time you would use the ear mold is when the hearing aid needs to be repaired.
Yeah, the problem is that she has dwarfism and so her ears are so tiny.
That it won't
She
work.
wears glasses and it falls off. I mean, we tried the smallest profile one and nothing worked. Everything just falls right off. So, yeah, to try and find something else that would be assistive for her in the classroom. Because the teacher, unfortunately, now is taking time away from the other students to re-instruct her in the classroom as to what's going on and spending inordinate amounts of extra time with her trying to do, that's taking away from the other students.
Is the 504 team has some communication or contact with the library accommodations, or does it has future plan about?
I can't hear you, I'm sorry. I'm not coming. I'm hearing a machine back there. Go ahead.
In the 504 have some plan or accommodation in the Seattle public libraries, because in the libraries there is no any facility for the aged children.
In the Seattle libraries?
Yeah, is there any plan to have, for example, like seating for pronunciation, how to pronounce something, there is no any source in the library. So do you have any plan or something?
I don't have anything to do with the libraries in Seattle. When you talk about the school district libraries, you're talking about the Seattle.
Even in school districts, there is no such provision.
And so tell me again what that provision is you're talking about?
Like pronouncing, for
Pardon me?
example, like pronouncing.
Okay.
Since they cannot hear clearly, so they need to read the lips. So some
Well, we have
schools-
speech and language folks that work with kids to help them pronounce more effectively, yes.
You mean the speech therapist?
Yeah, yeah. Yeah, that's who does it, and all the districts have that, or have access to it. Other questions? I'm gonna finish by just talking about some of the other areas where 504 issues come up. I've talked about discipline and expulsion. The bottom line on discipline is just to know that your kids have discipline protections and they cannot be long-term suspended or expelled for disability-related behavior. And the district has to convene a team and look at the situation that the kid was suspended for and officially decide whether it is or is not related to that disability. And the standard is, if I think that the behavior that I got in trouble for is a direct result of my hearing impairment, then I can't be long-term suspended or expelled. I need to have a behavior plan developed for me. And that's the bottom line on discipline for you. And if you get into a situation with a hearing impaired child where there's lots of suspensions and expulsions, it probably needs a reevaluation needs to be done. And so you should ask the district to reevaluate, look at the behavior, and figure out what's going on, because there's probably some relationship between the hearing impairment, I would suspect. And what I've found historically is it's usually some kind of a communication issue that's causing the behavioral issues, either between them and themselves or other kids. So that's important. Unstructured times in the school day are problematic. And again, your kids' access to lunchrooms and playgrounds is every bit as important as it is to the classroom. So if there's something that needs to happen in the lunchroom relative to the hearing impairment and some kind of an accommodation, it needs to be there also. Same way with the lunchroom. Transportation and field trips. I think this is probably one that gets to be controversial sometimes. And I give you an example of one that was a real one. Let's say a kid, it was a real case. A kid went out for a club, and it was a robotics club where they made robots, and they entered a national contest. And this deaf boy was in the robotics club. And the robotics team won a contest to go back to a national contest in Florida. Well, guess what? Now all of a sudden, where's his interpreter? And oh, by the way, whose responsibility is it? The conference is doing it, or the district. And oh, by the way, he's flying on an airplane for 6 hours. And oh, by the way, when you fly on an airplane as a kid to a field trip, part of the field trip is the airplane. So we had a lot of discussions about, well, do I really need to provide it on the airplane? And who provides it when I get there, and on and on and on. Bottom line is, the kid gets to go. He was in the club, they're going. If he needs an interpreter, then he needs an interpreter. Having said that, I just talked about a lot of money. One heck of a lot of money. And that's a tough one to solve. But the law's clear. But having said that, it's a tough one. And my recommendation is that, you know, a lot of times families will go with them on these things. They're exciting trips, and sometimes you could provide the service on the airplane so they didn't have to buy that, and then they have to work it out when they get back there. Because at the conference, he should get interpreters like everybody else for the instruction or whatever the activity is. So I think, again, my recommendation on all of those kinds of situations is that we all have to be on the same team, try to work with each other to make it work. But you shouldn't be hearing that he couldn't go on the field trip because we didn't have an interpreter. Or he got to go, but there was no interpreter, and then what did he learn when he went there? He didn't know what was going on. Medication, nursing services, that's not necessarily an issue, but we obviously have to make sure your hearing aids are working, and if one quits, then we need to try to work with you to come up with a solution for that. Extracurricular activities, sports, plays, I just talked about. If you can participate in it and want to participate in it, then you need to be accommodated. There's, you know, for example, one of the NFL players that went to the Super Bowl was absolutely deaf, played for the Denver Broncos, won the Super Bowl with John Elway, but he had accommodations all the way through his football career. Now, you don't have accommodations out there on the field. You're going to have to figure out what the umpire says. But when they're practicing, when they're training, all the way through his high school career, he needed assistance. I'll give you another example that's a live example, and that's a guy named Schlereth, who's actually on CNN, was a Super Bowl champion with the Washington Redskins and with Denver, was severely learning disabled, and in my special ed program in Anchorage. And we had to get left-right stuff with him. With colored stuff, he's also a great wrestler. But when he was young, we had to use a lot of accommodations in the practice field to help him overcome. You wouldn't know he's learning disabled now. I mean, you know, I still can't believe that knowing who he is now and what I was dealing with, that it's the same person. Because the guy is the most verbal, unbelievable person that you'd never expect that. But the fact is, when he was in the athletic programs, we had to provide accommodations for him.
So as far as extracurricular, like after-school activities, so if it is a school-sponsored, so a middle school has a soccer team, then the middle school should be providing an interpreter
Right.
for that student to
Yeah.
attend those practices.
Yeah.
What if it is a program that's put on by like the Boys and Girls Club, or it's a private, lacrosse club, but it's not affiliated with the school?
Then it's not the school district. And one other question, though, I think it was in some questions that were given to me. Private schools are not our problem. So if the parents unilaterally place a kid in a private school or Catholic school or whatever, the Catholic school may or may not honor Section 504. They don't have, now if they take federal money, then they have to honor 504 and would have to provide accommodations. Having said that, most of the private schools that I know of that are good, they go out of their way to accommodate kids because they want the kids there. And so they're pretty, but the law doesn't say they have to. So that kind of finishes up the formal part of what I want to do. I like to kind of end my formal presentation with this cartoon. It says, August 11th, 1959, in the heart of the Bolivian jungle, archaeologists discover an ancient and heretofore unknown sacrificial altar, but notice that they would be glad to make sure that your deaf kid got up there and understood that his heart was going to get ripped out like everybody else, so we could have an interpreter up there telling you, yep, you're going to die, just in case you didn't already figure it out with your eyes. But the reason I use this is really what you need to walk away with from a standpoint of 504, not special ed, but 504 is that we want your children to be able to come to school and to have all the activities and benefits of every other child. And we don't want his deafness or hearing impairment to get in the way. So we want to knock down all the barriers we can so that he or she has the opportunity to participate in and to get all the great things out of school, like participating in all the athletic events they are qualified for and want to participate in, going to the school plays, being in the drama club, having the same lunchroom, riding the bus like everybody else, getting straight A's, or, by the way, earned some of the bad things that you have in school. I dropped out, I flunked, I didn't do my homework, I didn't get an A because I didn't work hard enough. But all the negative side of the equation should be because I earned it, not because of my disability. So I don't want you walking out of here thinking your special ed or 504 kids can't get disciplined and can't get expelled, because they certainly can. They just can't get disciplined or expelled for their disability-related behavior. That we have to deal with. But they can still flunk classes if they don't work hard. They're not going to get an A unless they work as hard as everybody else for an A. We're not going to lower the standards for them and call that an accommodation. Because if you take a physics class and it's an honors physics class, then you have to produce honors level physics outcomes. And so that's what it's promising, and that's kind of what 504 is all about. So that's kind of what I wanted to cover today. Any other questions, issues?
My daughter is actually medically fragile. So how does all the medical and nursing stuff work out? She's still really young now, but she'll be
Well,
older.
A real common one, like we had a kid, somebody was just asking me about a kid with brittle bones, and what they were gonna do to kind of make that a safe environment within the school system. Our challenge with medically fragile kids is to work with the families and the physicians and say, what is it we can reasonably expect to happen in a school system to make it safe for them so they can participate. If they need some kind of nursing services on an ongoing basis, then we have to figure out what that is and provide it. Because as soon as she's school age, you know, she gets to go to school. And if she's in special ed, that starts at maybe birth or 3. And so if you're in the birth to 3 program and it looks like when you get to 3 to 5, you're still going to be eligible as a special ed student, then we're going to have to wrap around whatever we need to wrap around you to make your daughter safe and to deal with her physical disabilities, whatever they are.
I have a good friend whose daughter is very medically fragile, and they just fought with the Issaquah School District, and they actually built her own classroom because she can't be around any other children because of her immune issues. And so they have a special bus that comes and picks her up, and she has a special teacher, and she goes for a few days, a few hours a day, and they built a special classroom just for her. And so it was a long, hard fight, but that was the only way she could attend a school setting. So, you know, but you do have to start.
It's an individual decision, and it's an individual decision the team has to make. And I'll give you another example. I was a consultant for a district down in Vancouver, Portland, Vancouver area. And the kid had a severe latex allergy. And it's cumulative over time. And in elementary, they were able to put sort of a system around him. Got to junior high school, not so much possible. And at one point in time, it got to the point where he's just not going to come to school. There's no way we can keep a high school safe from latex. Not going to happen. And they don't expect us, OCR does not expect us to build him his own high school that's separated from everybody else. So some kind of visiting teacher, home, internet access is going to do it. And so again, because the arena of medically fragile is such a big spectrum, depends, we're going to do whatever we can. The law's going to make us do whatever we can do. But at some point, there's a place where no matter what we do, it's not safe. Another example of that is, let's say you have a 504 plan, and I talked about field trips, and maybe your daughter needs to have a nurse with us. But in your health plan, it says that, however, you have to be this far away from emergency response. If we go on a field trip that's further away than that, you don't get to go. Because even if I put the nurse in, it's not going to be safe. That'd be about the only exception that we would have where we'd say you don't get to participate. And sometimes we have to fix that issue. Okay, sir?
Earlier you mentioned something about age 8 being a key age for eligibility issues. Could you
Yeah,
expand?
only on one disability category, the birth 3 category of, is it developmental, you can say? Yeah, I always confuse me, they have the same language as the other two. But anyway, there's one category, now in the birth 3 category, it's an at-risk Birth of 3 separate from special ed, separate from 504. And in the special ed wax, a kid could be, could keep that label all the way to age 8, if he still needed specially designed instruction for special ed services. It's not honored in section 504, so if you get sort of in the never land where you're not eligible for special ed in 3 to 5, and you may not be eligible for 504 under that label. However, I will tell you that section 504, because it has all these other disabilities that aren't in special ed, there can be some other processing disabilities and things that aren't special ed that a kid might qualify for. So there's other disability categories that may be pieces of what got you into the DD label as a preschool, as a birth to 3. So you have to open our eyes to those other disabilities. Under 504 only. Special ed, there's a set list of them. And when the kid runs out of age 8, because you can't keep that at-risk label past age 8 by special ed law, you have to find one of the categories in special ed or you're not eligible.
Oh, okay, so at 3 to 5,
You could still keep it.
you'd be identified at risk.
Yes, well, you still could keep the DD. Yeah, I don't want to say at risk because we're saying it's a disability, even though in reality it's pretty open. But there are criteria. So the DD label in the special ed wax has some numbers attached to it that assessments are tied to. So you have to meet the criteria of DD.
Oh, okay.
It's not just you're in, you're never going to look at it. So we will look at it, but as long as you still meet the DD criteria as opposed to a hard category, you can keep it. And if you want more on that, you might just talk to the early childhood people in your district and they'll explain it maybe more effectively or show you the real whack you can read it.
Well, yeah, based on your description, I don't think it applies for us.
Okay.
I just wanted to make sure.
For kids who are in high school and are looking at ACTs and SATs, is it beneficial to have a 504 plan in place so that you can get more accommodations on taking the SAT and ACT? Or, because I had a kid who didn't really get diagnosed like with ADHD until senior year, and they said the ACT said you didn't have enough
Right.
data or wanted
Yeah, see,
to.
ACT and SAT have their own rules for what they're going to say.
Right.
So, and it's kind of like our Washington State assessments. They really expect that you needed that all your life. If you all of a sudden get it because you want it on the SAT, they're going to say no.
Yeah.
Just like if all of a sudden a week before the high stakes testing, it's against our rules in the state of Washington to all of a sudden put an accommodation plan or special test. You need it, in our rules, you need it for ongoing instruction in that academic area if you want to get a certain accommodation on the math test or the reading test, high stakes.
Because I try to counsel families that, kids with hearing loss, that it's better to kind of keep the 504 so that down the road, if they needed some accommodations on the ACT or the SAT, it wasn't all of a sudden we're putting in place that you have that history, if they qualify.
Well, yeah, if he needs it, he needs it, but it shouldn't be that he needs, if the SAT people or ACT decide that the only reason he needs it is to take the SAT and to get a better score in the SAT, then they're gonna say no.
Right. But some kids need some of those accommodations to do as well as they cognitively can do on those.
That's why I think it would be important, to make sense of that. Okay? Yeah.
Can you educate me on the federal dollars that follow the IDEA? And here's my situation, we're in one district, my daughter has an IEP, we want to transfer school districts to a different district. They say you cannot transfer with an IEP. And wouldn't that be better for them, because they would
Wait a
get
minute,
dollars?
You can't say- Not only do you can't say that, there's specific regulations that say if you transfer from one district to the other, I have to take your existing IEP and implement it as best I can in my district until I can reevaluate you and decide
Any public school, even if it's an ALE.
anywhere in America.
Okay.
So are you talking about
My
changing
situation, right?
districts, residential changes?
Not
or-
residential.
Now, if you're gonna go to another public school
Yes.
in America, anywhere, The rule is I have to take your IEP, implement it as is or as close as is as I can do it. For example, you might go to a rural town that doesn't even have a self-contained classroom, so I obviously can't just create one for you all of a sudden. I'm gonna put you in that resource room, do as much as I can until I can, sit down and come up with an appropriate program in my district. But they can't say, you can't come here with an IEP.
They can't not accept us because we have an IEP.
Well, now, if you're doing choice, now here's a different deal. If you have, in our state, we have a choice law. Choice law says you can move from your residential district, go into a non-residential district. Is that what you're talking about?
Well, we live in one town, we wanna move to the next town.
Are you gonna move
No. We live in one town, we're gonna change schools
to another school
to
district?
another school district.
That becomes choice. There's a
Okay.
whole set of rules for choice. Part of the rules aren't that you don't get to come if you're a special ed kid. There's choice rules you have to apply. Your district, first of all, your home district has to let you go.
Yes.
There's choice rules. And then the district has to consider you. Now, there are certain criteria. They could have, there are criteria for rejection of a choice kid. And the criteria are that school is full, or that, say, you wanted to come to my autism self-contained classroom, I'll just say my deaf classroom. And it was, I had a specific amount of kids that were allowed to be in the classroom, and it was full, I could say it's full. And OCR made this decision, because we had a lot of people playing funny business with, well, I don't want to take you because, you cost money or something because you're a special ed kid. First of all, the minute I take you, I'm gonna get the special ed
Don't you
money.
get the dollars?
I'm gonna get the same
Why
amount
would
of
they
money
not
as the
want
other
it?
guy
I'm so
got.
confused.
Well, I'm gonna get the same amount of money. Now, I don't want you to get the idea that the money actually follows you, the real money actually follows your kids, because districts say you have this many special ed kids, and they get so much money from the state, and there's all kinds of complications to it, and that amount of money isn't what's guaranteed. Just because I'll just say, let's say your kid, all kids generate, I'll just say $6,000. That doesn't guarantee I have to spend $6,000 on it.
Sure.
I'm gonna spend what I need to spend. It could be $20,000. In most of these cases, it costs more than what they get. But the funding is designed to give us a pot of money, then we apply it. So I don't want you to think the money per se tracks to you, but first of all, the law says choice has its own rules, so you gotta put it by choice. There's only one exception to you can't come, and that's the district can make it clear that they're full. And there's protest. You have ways to go to SBI and say, I don't believe it. And if you thought you got kind of finagled in the process, you could say, I thought I was discriminated, you could file a complaint with us. It doesn't cost you any money. They would investigate, look at why the district turned you down or didn't turn you down, and decide whether they played by their interpretation of the law. In essence is, the only excuse I have for not accepting a choice kid, because all kids in the state of Washington have the right to choice, is that I'm full.
What about the home district? Do they have the right to not
Yes.
allow the child
Yes.
to leave?
Yes.
So they can say, no, you can't have choice.
Right.
Okay, so then.
You have to be released, because when I release you, they're gonna be able to count one of my residents.
So how do you counter that if they won't release you?
There's choice, there's a process in choice protest, but I don't know that you can get out of it. I have to let you go. That's the choice law. It's not special ed, it's not 509. It's choice law.
So you gotta have your home district to agree to let you go,
Yeah.
and this, in other district allow you to come in.
Yeah.
So you got.
And the other one has to let you come in unless they can show that there's a burden, which is, I have to be full.
Right.
Not that many burdens. But you'd have to go to, I can do special ed off the top of my head, but I can't do all the details of choice. But I know the basic concepts and that. But there may be some other little qualifiers in there about releasing and denial. And I know there's a protest process. So if you're getting the runaround that way, then do that.
Or if they need some education, who can they call? If the school district needs education, when they tell me, you cannot come because you have.
You can, what I would recommend in that case, you could call me, but you could call SBI Special Ed Department. They answer parent questions and they deal with choice. And they'll help you through that. And we get choice issues with districts all the time with SBI. and in the district, and we'll try to sort them out.
Or Jim, we could just convince Lisa to become a teacher in the district she'd like her child to go in, and she could automatically choice into that school, which would be a great solution.
Actually, we looked into this, we were looking at the Washington Virtual Academy,
Oh, yeah.
and our interpretation of that particular WAC says, yes, your home district can say no, but they darn well better have a good reason for doing it. They can't just say, no, we don't want to let you go. They have to have a documented reason, and it
And if you're
better
good-
be really, really good.
Yep, and most districts are more than happy. They're not gonna fight it. The other issue is, you mentioned virtual academies, and we actually, I worked with OCR last year with the whole community, and we basically put virtual academies on notice. If we also have to accept special ed kids, we can't say I'm a virtual academy that doesn't accept special ed kids on their Facebook. To get into that, there's the Virtual Academy, there's a website at SBI, there's people in charge of virtual academy type stuff, and they can help us.
I have a mentally ill daughter. She's turning 20 this month, but she's in Inside School of Washington. So she's finishing up trying desperately to finish her senior year and graduate. She has an IEP, but they're not following it. Can I call SPI? I mean, even though she's
Technically an adult.
technically an adult.
If she has an IEP, she's still, and she hasn't graduated from high school.
Right.
And she's still under 21, she's still eligible, yes, for SBI.
Okay.
They'll help you sort that out.
Because they're trying to make her take history and algebra and things that she's just not.
Well, she's gonna have to go through, we're gonna have to work through history stuff by the rules of OSBI.
Okay.
And special ed still has to do the same thing. But there's ways of, there's alternative assessments, depending on the type of disability. It's complicated. In fact, I'm gonna do a training on it Saturday, or Thursday with our ESD.
Oh, where are you?
No, this is for the ESD directors, but it's trying to sort out the graduation wax and special ed and some of the confusion.
Yeah, it's really becoming an issue.
Well, I am going to finish. I have to go home, I got a long commute.
Did you have your contact information here somewhere?
Yeah, I will give it to you, okay? It's, my email is the best way to do it. It's easy, jrich at PSESD, Puget Sound PSESD.org. You email me with a question, I'll get back to you that day or the next day. If I need a copy of, always give me your phone number, because if you ask me a complicated question, I'm not gonna put it right. Anyway, thank you. I hope this was helpful.